Hello, my name's Ken Novenstern. I'm an attorney partner with Fredman Baken and Novenstern in White Plains and Mount Kisco, New York. And actually, I'm coming to you today from our Mount Kisco office, which is a home built probably in the 1840s. So you might notice the fireplace and wood behind me. I wanted to talk today about dividing retirement benefits in divorce in the Majauskas case. And the Majauskas case was decided back in 1983 by the New York Court of Appeals, which is the highest court in New York. And interestingly, the equitable distribution law in New York, which controls division of assets, spousal maintenance, etc., went into effect a few years before in 1980. So when I started practicing in the area of matrimonial law up in Syracuse in 1985, the equitable distribution law was just getting parsed out, which happened over the period of 10, 15, 20 years. And the Majauskas decision was part of that. One could argue that the equitable distribution law continues to get parsed out by various decisions. In the Majauskas case, it involved the division of a defined benefit pension. Retirement benefits are generally broken down into defined benefit or defined contribution plans, and we often have to deal with them in the context of divorce. With defined benefit plans, often they involve employees of municipalities, whether it's the state of New York, a teacher, New York City employees, and there are fewer and fewer employers that offer pensions. So when we have to deal with the division of pensions, it's very important to have experience and knowledge in doing that. And you have to be very careful concerning the phrasing of the provisions in the stipulation of settlement concerning the division of the pension. You have to make sure that you utilize services of a pension actuary. And there are parts to dividing a pension, including the application of the Majauskas formula, clearly stating that you're using the Majauskas formula, pre-retirement, post-retirement death benefits, cost of living adjustments, and other aspects of the retirement benefit that, if clearly stated in the agreement and incorporated into a judgment of divorce, will properly protect you. Attorneys like myself regularly see situations, agreements from 10, 15, 20 years ago, where the drafting was not done well. I just finished a litigation which started in 2016, and we had a domestic relations order signed by a judge in Putnam County, New York, and it protected our client. And the other side ended up litigating the issues because the wording in the agreement may not have been as clear as it should be. And we ended up getting a decision on an appeal last week. So from roughly August 2016 until August 2020, we had to litigate issues surrounding a defined benefit plan pension through the New York City Employees Retirement System. And fortunately, the appeal came back in our favor, and my client is receiving her full share of the pension benefit of the husband's pension, which is over $3,000 a month. And based on the husband's argument, it would have been closer to $1,200 a month. So it's very important that you get it right the first time. You may not get a second chance. So my name's Ken Novenstern. My number at the office here in Mount Kisco is 914-241-2400, and I look forward to talking with you.